Well, hello everyone, and welcome back to Uncivil Law. As always, I'm your host, Uncivil Law. Sorry that you missed me during the break, but hopefully you didn't miss me too much. I regret to inform you that our audio test that I tried to do did not work. So I wasn't able to get the super duper enhanced audio working. So we're just back to what I was previously doing. So we still have the old audio enhancement, but not the super duper great audio enhancement. Wasn't able to get it work in the time allotted, but it was worth a shot in any event. But we might give it another shot another day, but not today. But we did our best. We turn our attention once again to the Karen retrial, wherein we're going to hear from ARCA pretty soon, and that's going to be exciting. So we're all looking forward to that. So we'll see how that's all going to go, and we'll go from there. And ARCA is spelled with two A's, right? A-A-R-C-A? Or A-A, how do you spell ARCA? A-A-R-C-A? Yes. A-R-C-C-A. Not the right one. A-R-C-C-A. Okay, voir dire hearing ARCA. All right, we're all ready for that to get started. Everything is fine. Everything is awesome when you're listening to the beat and so forth and so on. How y'all doing? Y'all doing good? Great. Fantastic. Take deep breaths, my friend. Deep breaths. Deep breaths. Is Bev doing the questioning? No, the attorneys will do the questioning principally, although Bev may ask some questions. Yeah, and this all is relating to what will ARCA be allowed to testify, and if so, about what, and are there any penalties against the defense team, and if so, what, and so forth and so on. So that's what we're talking about today. And yeah. And also try not to dwell on criticisms of yours truly, because it's in my head now, which is probably why the person who brought it up in chat brought it up in the chat. They probably wanted to get inside my head, and they have succeeded. So the trolls have succeeded at getting inside my head, and that is exciting and fun for everybody. But that's okay. We're going to try to press on. Also, we may have a merch thing later, so that might be fun. We'll see. I have no knowledge of any deleted text messages, Jim, and even if they were deleted, they might have been deleted in the ordinary course of business, and that question is loaded and not well appreciated. Let it go, Kurt. Well, it's not necessarily easy to let it go sometimes. That's why I mentioned it. But, just let it go. All right, that's, okay, consider it gone, I guess. That was easy. Yeah. We'll see how we can do. I don't know if there are any deleted messages. If there are deleted messages, I don't know if they were deleted in the ordinary course of business. I don't know if that is proper within the meaning of the rules or not. They cited some ABA rule, but of course the ABA has absolutely no power. So I don't give two shits what the ABA says, because they can fuck right off, because the ABA has no power. Rules are determined by state level, not the ABA. The ABA wants to be a bar association, but they're not really. They just pretend to be one at parties. So the ABA might have some guidance and stuff, which of course doesn't necessarily mean the judge won't use it as authority, which I then suppose makes it authority. If the judge cites it as authority, it then becomes authority, but it has no inherent power. So, yeah. But yeah, were the messages deleted at all? If so, were they deleted in the ordinary course of business? If so, does that violate an ethics rule? If it does that create a problem? And many other issues. And even if all those things, what remedy? So many issues to be decided. So all that good stuff. As we take deep, deep breaths. Reflecting on yourself is the road to unhappiness. Usually being self-reflective is normally considered a positive, but okay.
You are unmuted.
Yeah, we're unmuted, we know.
Thank you.
We're back in session, you may be seated.
Oh, hang on, Grant.
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present, the jury is not present.
All right, thank you. All right, so we know that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the ARCA witnesses. Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCA witnesses or to exclude their testimonies. Upon that, I believe, I issued an order last week for certain discovery to be provided and to be provided by ARCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially...
Also, by the way, just minor annoyance in my own life. When I was trying to fix all the settings, I accidentally deleted all my own microphone settings, so I tried to put them back in place. So if there's sound issues, we'll try to fix them, but I accidentally deleted all my microphone settings. So I try to put in place the critical ones, but
given what the defense has failed to deliver, I would not permit the defense from mentioning ARCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So Mr. Brennan, who are we going?
There might be an ARCA part 2. That's exciting. Maybe we'll have ARCA part 2.
First, Dr. Wolfe.
Please.
Dr. Wolfe. Dr. Wolfe does not have an associate's degree. Therefore, he is not qualified. We know that. He's not qualified, Your Honor. He doesn't have an associate's degree like Mr. Paul does.
You're going to face the clerk and raise your right hand, please.
I solemnly swear that the testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Can I
I'm Dr. Wolfe. I'm here to solve problems.
Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that?
We need Dr. Wolfe to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolfe, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Ms. Little, last year I was under T-Mobile was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to, are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time, who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
I am getting pissed off. So, for the Elisa Clip fans who are looking forward to me spurging, there may be some more spurging involved, because this hearing is some bullshit. This hearing is some bullshit. And these questions are some bullshit. So my we're like 3 minutes into this, and I can already feel my blood boiling. Let's try to take deep centered breaths. All right. Let's listen to some more of this bullshit.
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Ms. Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please. Thank you.
This is a goddamn witch hunt. That's what's going on now. We're doing a good old-fashioned Boston witch hunt. I saw Izzy Proctor speaking with the devil. Hold me.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on the
Yes.
defense team? Who?
I believe Ms. Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
Really?
I don't recall.
No one cares.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolfe, or are you still answering?
I would still try to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why wasn't you talking about fees and schedules if you didn't think that you were potentially going to get hired?
What the fuck kind of
Again,
question is
I
that?
prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately.
Why would you discuss your fees if you didn't think you were going to get hired? Isn't that kind of standard? Right? I mean, if you came to me as an attorney, I might talk about how much I'm going to charge you because that's kind of information you might need to know. What kind of question is this? It's like, okay.
Immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling?
Why do you
and
think?
Being paid at that point?
Objection, Your Honor.
Why do you think we were talking about it? It was basically our first conversation, and during our first conversation, I let them know what our standard practices are and our standard fees, because they were contacting me presumably with an eye of potentially retaining me. And so one of the things I talked about in our first conversation was like what we normally do in terms of our normal business operating procedure, including potential fees, because that's kind of information you might have in a first conversation. What the fuck kind of question is this?
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process when a client reaches out and wants to engage us for trial testimony. That's typically, again, the procedure that we prescribe at ARCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
But what happened later is part of the reason he's drawing the delineation. Right? He's like, well, why do you think there's a difference between being retained and being hired? It's like, well, because later on, like we had a conversation and it's like, oh, you can't be retained, but you can testify. So that's why I'm drawing the distinction. Well, I'm asking earlier. It's like, but that's why I'm drawing the distinction now, because there was a distinction. At least there turned out to be a distinction between the two. I mean, normally me testifying as an expert and me being hired, probably the same thing. Normally that's kind of the same thing. Why am I testifying if not an expert? And why am I testifying if not being hired? But in this particular case, there was a distinction because the DOJ said, well, you can't sign a retention. So I guess there is a distinction between testifying and being hired. In this context, there is a distinction. So that's why I gave the answer. What more do you want from me? I did my best to answer your question. You're killing me, Brent. You're killing me, Brennan. You're killing me.
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022, not the 22nd, not the 24th, March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Yeah, you're trying to pin me down on this being hired thing. Like you're trying to pin me down to your word choice. And this witness is too smart for that. It's like, I'm not going to use your word choice. It's like, okay, was this about being hired or not? Well, it's like, well, depends on your point of view a little bit because of everything that happened, right? It's like, so I'm not going to be pinned down to your word choice. It's like, was a discussion about you being hired? Was a discussion not about you being hired? As it turns out, it's actually more nuanced than that. And again, you wouldn't typically expect that to be more nuanced, right? Were you discussing being hired or weren't you being hired? Well, actually, it's kind of neither of those things. How can it be neither of those things? Let me tell you why it's neither of those things. In this particular case, I had the same conversation I sort of had with anyone, wherein I laid out our typical fees. And then it turned out that they actually couldn't retain me. So we're in some sort of weird universe where I'm working for them, but haven't been retained or hired by them. So we're in some weird universe where this is apparently what's happening. I'm working for you, but haven't been hired by you because I'm not allowed to be hired by you. But yeah, so we're in this sort of weird universe where these distinctions at least make sense. And I'm not going to buy your premise. I'm not going to buy the premise of your question. You go, Dr. Wolfe, you tell him.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
This is the dumbest exchange I've heard of in my life.
April.
Right? This is really weird. This is a really dumb exchange. Okay, so this guy is working for the US federal government in a case that has overlap to this case. And so that gets into potentially strange issues relating to that because he has knowledge that from working with the US attorney, he has potential issues that could potentially be problematic. So we're into some weird sort of nebulous space. And at the moment, we're trying to make everyone happy at the same time so we can all work together, right? I mean, maybe the defense could force it, and say, screw you, U.S. attorney, although he probably wouldn't be down for that because he kind of wants to keep them happy. But, he isn't entitled to them as an expert witness. I mean, they can work for them or not. And they already have a client, namely the US government, and they'd like to try to keep their client happy. And so they're trying to coordinate about this whole thing. And so it's like, okay, basically what happened? Well, first of all, they had a conversation. Okay. And what was the conversation? Basically the conversation is, what do you want? Why am I talking to you? All right. That's the conversation. What do you want? And it's like, well, we might want you to participate in the Karen Reed trial in some way. I was like, okay, well, let me sort of explain to you our standard processes, how we normally do things in normal world. And now I've got to go turn around and talk to the US attorney and see if it's cool with them now that I sort of understand what it is that you want me to do. Like, can we do this? Right? This is normally what I would do, but I'm not 100% sure if I normally can do it. So let me explain to you what we normally do in normal land. Then I'm going to go turn around the U.S. attorney and see whether or not we can do that. And then I'm going to get back to you on what modifications, if any, there are to the standard process. This sounds like a perfectly banal conversation. Brandon is trying to make it sound like the most nefarious thing ever. It sounds banal and basic as shit to me. It's weird. It's weird. It's definitely not a conversation you're going to have every day, particularly because it involves the prosecution of the federal government, namely the DOJ. They're the prosecution of the federal government, unless you didn't. So it involves the prosecution of the federal government, in this case, not cooperating with the prosecution of a state, which would be more common, right? In which case we have more relationships because we sometimes talk to each other as we do. We have the prosecution of the federal government trying to coordinate with the defense in a state case. That's a little weird. So we're, to some degree, we're kind of making it up as we go along because it's a little outside the norm. And we're trying to figure out what the rule set is because it's not our normal MO. We don't normally do this. We're trying to figure it out. He makes it sound so nefarious. It's ridiculous.
How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you
and the DOJ, unsurprisingly, wants to protect their interests. Wow, amazing, right? I mean, if it were a private attorney, if this guy was my expert witness and it somehow overlapped to your case, right? Somehow we had a case, but I got to him first, right? I'm going to want you to respect my turf because I got to him first. He's my expert at the moment. It's like, I want you to respect my turf. So yeah, we're trying to figure out how are we going to make this work, if at all. Maybe I'm like, no, you can't have my answer is no, you can't have my expert. Go get your own. This is my expert. No, you can't have him. But we're going to try to work out something together. So, but I'm also very concerned about my interests and my work product and the conversations I've had and, not sacrificing any of my clients' interests. So also that. And then on top of that, I'm not just a random attorney. On top of that, I'm the DOJ with levels and supervisors and reviews and blah, blah, blah. So, all those things. So this sounds like a conversation I could see myself winding up in as just an attorney to attorney conversation. Sounds pretty normal to me, although unusual. It doesn't sound like it doesn't sound like a conversation I'm going to have every day. But if I were to have this conversation, kind of sounds like a conversation I might have. So it's like, this sounds normal to me within the confines of the universe we're in.
Out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Yeah.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense? Do you feel like you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and in the analysis that I've done. That's the
You tell him, baby. You tell him.
Because after that 424 call.
Really? Are you sure? Really? You asked the ultimate question? Are you sure you're neutral? Don't ask the ultimate question, you putz. When the defense asked the ultimate question, I called them putzes too. You're also a putz. Don't ask the ultimate question, you putz. Don't do that.
Letting them know that the United States Attorney's Office gave permission for you to be called as a witness. You called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
You did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission, they could use...
Anyone want to tell me at what point I'm supposed to care? If anyone tells me at what point I'm supposed to care about any of this, that'd be fine.
you as witnesses. What did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls?
This is gonna be a long day.
You called Attorney Jackson and said you had the green light from the U.S. Attorney's Office. Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCA was as a whole. I think we even got stuck a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes. Specifically what they were to, I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April still?
Yeah, I'm still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir,
Well, I wouldn't know.
That is my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
You wouldn't know.
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Okay. Do you remember the call on May 1st, 2000?
This is so incredibly stupid. This is so incredibly stupid. All right.
2024.
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that
Asked and
40-minute
answered.
conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCA, but never ever talked about this case.
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCA. That doesn't come back to Dan Wolfe.
Okay, so in order to get paid for that, you would have had to submit that time through ARCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes, I keep track of my time so that my boss knows what I'm doing, yes.
Okay.
Your Honor, can I approach, please?
Who asked me that?
Your Honor.
Yes. Come on over.
This question, this is so fucking stupid. This is so fucking dumb. There's nothing here. There's nothing here. This is incredibly fucking dumb. This is stupid. This is absolutely a waste of time. That, of course, will not preclude Bev from in any way from making whatever ruling she's going to make. I'm just saying that there's nothing here. She can pretend there's something here. She can rule there's something here. She probably will rule there's something here, but the ruling's going to be bullshit because there's nothing here. It's going to be fucking dumb. I haven't seen someone try to manufacture something out of nothing this hard since I reviewed a petition for a writ of certiorari yesterday. What a dumb thing this is. Can we briefly type in all caps to rage? I'd have to actually go in and disable the bot so you could type in all caps to rage, but I'm tempted. I'm tempted. You know what? Fuck it. Let's do it. Fuck it. Give me a second. Fuck it. One moment, please. Where is this thing? Spam filter. Caps protection is now turned off. You can now have all caps.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Okay. Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCA, talking about your families?
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my
Oh,
family.
now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related.
I'd bill for it. I'd bill for it. I'm charging you for my time. If you call me as an attorney and we start having conversation, it's your time, man. And I'm billing you. I'm billing you. So yeah, if you want to have a conversation about the weather and, our kids, I'm billing you at $3.50 an hour. Sure. We can have a conversation about that too. It's your time, man. It's your dime.
That much time to talk about ARCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. I think Alan contacted me, letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
Nice answer. Nice answer.
Do you remember the next time you spoke to Alan?
Although I'm not 100% sure that's true. That might have been a little light perjury. Do you really think you would call Mr. Brennan? I don't know, man. I don't know. I think there might have been a little light perjury by Dr. Wolfe just now. I don't know. That was the first thought that went through his head.
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
By the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete text?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
After the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete text?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here. I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
So next question, no comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know.
I don't know the number, sir.
You don't know the numbers?
I didn't count them. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was it 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
I don't know.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial.
Where were you when you were deleting these texts? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you were?
I just said I delete text routinely. You're asking me to specifically give you a location at a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
What kind of fucking question is that? Is it typical for a biomedical? What the fuck kind of question is that? Also, to talk to an attorney in particular, probably not unheard of. Yeah, I mean, yeah, you know, probably, yeah. It's okay. What the fuck kind of question is this?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
It's an encrypted app, isn't it?
What's that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a...
Fuck off. Fuck off. What kind of fucking questions are these? What the fuck?
It's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted app when you're talking to attorneys?
If the client...
You know, actually, there's actually a reasonable case to be made on this point as a matter of attorney's ethics. While we try to learn something of legal value, okay, so that I can try to extract something of value out of this conversation, okay? Attorneys have a duty to keep their client information confidential. Exactly what does that encompass is a matter of some discussion in the bar as it relates to cloud data and stuff like that. So, like, there aren't necessarily any hard and fast rules here, but you know, there's a lot of seminars and there's a lot of discussions and there's a lot of CLEs as it relates to things like this about, you know, should you just use normal email or should you just, you know, should you do this or should you do that? There's a lot of discussion relating to this and best practices. And, you know, some attorneys might use Google Drive and some might not. They might want something that they feel like that's not secure enough. There's a lot of discussion on this point. So it wouldn't strike me at all weird that an attorney would want to have an encrypted text communication chain relating to their client work, as opposed to just sending SMSs and the clear, right? I mean, maybe that's secure enough, but you know, some attorneys might be a little bit more concerned about that. And so some attorneys might be like, no, I don't want to use standard SMS because I want to ensure confidentiality. I want to have end-to-end encryption. So I want to use something like Signal or WhatsApp or whatever because it's going to ensure end-to-end encryption. There are non-trivial concerns relating to this discussion. The bar talks about this kind of issue. They talk about it a lot. So you trying to turn around and be like, is it weird for an attorney to use Signal? No, not really. I mean, it wouldn't necessarily be strange. It wouldn't necessarily be the most common thing, but it also wouldn't be weird because of the very fact it's encrypted end to end. I assume that Brendan is aware of these discussions on the bar. I assume he does CLEs from time to time. They do talk about it. Lawyers in chat, lawyers and paralegals in chat. I know there's some of you out there. Tell me that I'm wrong. Tell me that this isn't an issue. The bar has spent some time talking about it. Tell me that there isn't, discussions relating to best practices when it relates to digital data and security and encryption. Tell me that this isn't a bit of a discussion point. Back me up on this one. I'm not alone, man.
Client has that preference. I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations do you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible, so we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know.
You don't want the PhD to think? That's going to be difficult.
How many times did you use Signal with the defense to talk about this case?
Objection, Your Honor.
Going to allow it.
From what I recall, was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right, I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times?
MG Law, do you want to join me or something and rage at this? Because I feel like I shouldn't be alone right now. I need some attorneys to join me for the raging. I need more raging support. I need rage support. Is anyone available for rage support?
Times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Probably 4 to 5.
Well, was it 4 or was it 5?
Give me a fucking break!
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal? The 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
You're
yes.
putting it on a timer? Each one had to be a maximum
Fuck
of 5
you!
minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Objection, Your Honor.
Can you answer that? How confident are you, Dr. Wolfe?
I can't answer that anymore.
Okay.
When you
Next
were
question.
required by court order to provide all of the records to Your Honor, you knew that one of the important things you need to respond to were communications between you and the defense for Her Honor to consider, right?
Yes,
And Signal is a communication, isn't it?
certainly.
You looked at all your records and you knew it listed the text messages and the phone calls. You knew that, right?
Yes.
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
Yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you.
Lawyers in chat, lawyers and paralegals in chat, please tell me I'm not alone. Is this one of the stupidest series of I don't know what this legally is at this point. Is this Is this one of the stupidest interrogatories, voir dires, or whatever this bullshit is at this point that you've ever seen in your life? Because this is pretty fucking stupid. I know there's a lot of stupid out there, but this is pretty stupid. Is this one of the stupidest interrogatories, stupidest interviews, stupidest voir dires, stupidest, is this one of the stupidest whatever these things are? Because it's pretty dumb. Help me.
Is when you responded to the court order to provide all communications, and you responded by offering text messages, and you responded by listing phone calls. You knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you.
If you called me in as an attorney, if you called me and my client in as an attorney, and you called my client in for a deposition. You call my client in for a deposition. I'm the attorney representing the client for the deposition. And you're asking questions this dumb, I'm walking out. I'm walking out of the deposition. I'll ask the judge to find you in contempt. Yeah, knock yourself out. Fuck you.
You knew the signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that they were phone calls through signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession.
Objection. Are you fucking serious right now?
Sir.
During those 4 to 5 signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
I
first.
said there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
Dr. Wolfe, I'd like to buy you a drink. My chat and I would like to buy you a drink. Send me your Venmo information or something. You deserve a drink. Look at this guy's face. Look at this guy's face. This is the face of a guy who is way too educated for this bullshit.
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the costs of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time.
Yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements,
Do you know how salary works? Do you know how being on salary works? Do you understand that concept? I'm paid the same no matter what. But my boss likes to know how I'm spending my time because it matters to them. So it didn't matter to me. I'm getting paid no matter what. But yeah, my boss likes to know how. So what part about this is confusing? Do you know how being paid on salary works?
Did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with.
I'm losing the will to live.
Others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Without qualification, the simple question is, you've met Kat, haven't you?
I think I met her, it was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Who escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street, and I think she walked me over, and then ultimately when I was done, I think she walked me back to the lot.
Do you have conversations with anybody for the defense about how you would get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it, and it was.
Your question is, did the church parking lot mean anything to you? It meant it was a place for me to park. What are these questions? What are these questions? Make it make sense. Make it make sense.
It was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Is it remarkable? Is it pretty remarkable?
Pretty remarkable event, this trial.
Is it remarkable?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking
Who
lot where you met with
cares?
them?
Yes.
Who
You
cares?
shook his hand. This is meeting face to face.
Yes.
Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so.
You know, it has been a very long time since I've drank hard liquor on stream. It's been even a longer time since I've drank it straight out of the bottle.
Do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would need it. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. And I can certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there. We're going to get there, but there's a lot more.
I bet we are going to get there.
Before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
Okay. You ultimately have more conversations on June 16th. Remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
Okay. So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with the client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here, because I know that I was going to, as opposed
Well, as I recall, our discussion was about the bug up your ass. Did you ever get that address, the bug up your ass?
to drive in, I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report, 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
Oh my God. Help. Help. Help.
Showing you an email. Do you recognize that?
Yes.
From you to who?
To Mr. Jackson.
Okay. And what's it labeled as?
Wolfe Direct.
And that's before you testified on trials, 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
There's an email with a document that like the attaches to the exhibit.
Okay. Exhibit 1.
Melanie Little's losing her mind. Yep, I'm losing my mind too. I'm pretty sure Melanie Little's also losing her mind. Is Melanie Little using the cursey words yet? Has she devolved into cursey words? That doesn't really seem like Melanie Little's MO, but yeah, this is some bullshit, man. This is pretty heavy bullshit. Yeah.
Exhibit 1.
Is Emily D. Baker streaming? How's that going over there? Probably not great either.
So you assisted the defense before your testimony.
Hold on.
Thank you. So you assisted the defense in anticipation of your testimony by sharing.
I look forward to the clip compilation of this. That should be pretty entertaining. Back to this bullshit.
Then the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question.
Hold the comments, please.
My question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can.
I bet.
So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful? Do you want to answer my question, or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized this, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Sustained.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document, you said you just sent it because this is a standard thing. Why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your question.
You don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
I'm going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked, if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they're going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely, and it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay.
Wait, I super chat Melanie. What's she saying? Hold on.
Brennan has rage. I mean, his rage is obvious.
May I allow the witness to have that?
1 second, please.
Take it.
I guess see.
Can't help you. I can't help you on civil. He's got so much rage, doesn't he? You have rage, or Brennan has rage? I mean, his rage is obvious. It's palpable.
Yeah, I have too much rage, Melanie. Thank you. Going back to this.
You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Sir, there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles, who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone and the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not.
I might have to go visit a rage room. I might have to go visit a rage room after this. Who wants to go with me? Anyone in the Houston, Katy area? Anyone want to do a rage room? I might need it, man.
Not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. Yeah. That's what I was trying to make sure that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then, do you defer to the defense, not the jury, trying to give the full story to the jury, do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Let me explain.
No, I'm asking you, did you
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it and then you can give any explanation you want.
Hold on. Question, Mr. Brennan,
You
and then
said-
you answer, Dr. Wolfe.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because, for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in the statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31, have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to...
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not, correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial 1?
Yes, trial 1.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face-to-face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCA did send an invoice afterwards, yes.
Did you talk to ARCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
You know, I anticipated that this would be bad, but I grossly underestimated exactly how bad this was going to be. This is one of the most distressingly bad faith depositions, voir dire, or hearings, or whatever exactly this thing is that I've seen. This is a wasteland of stupid on levels that's truly hard to comprehend. I mean, this has been going on for what, a half hour at this point, and I'm losing the will to live. This is so incredibly. I've run out of adjectives. I've run out of words to describe what this is. I have nothing but rage and disappointment and sadness left at this. This is, I need a stronger word than ridiculous. I need a stronger word than absurd. I need a stronger word than, I need more. I need more. I need more.
Arca submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was
asinine isn't bad.
Again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement, and ultimately he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
Hold on. I said something, Melanie, again. Let's see if she responds to what I said.
There, sir?
Yes.
Kurt, I can't help you if you have an aneurysm. Call 911.
Let's test to make sure. March 20, 2000.
Thank you, Melanie. We appreciate the love anyway. Lord.
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
But your report's never very clear who did what. Would you agree with me the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it, yes.
It doesn't distinguish who did what in that report, does it?
Correct. I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be
nice.
easier to understand if you could just tell us what the conversation was. That's what I'm asking about.
Objection, Your Honor.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, again, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
Okay. During the voir dire and the trial, did you get to watch any of the Commonwealth experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And sir, is there any other communications that you've had with the defense that you didn't tell us about outside the texts and the phone calls and the signal calls, or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
All right. Mr.
All right, guys. Let's just take a moment to recenter ourselves a little bit before we get back to, listening to the defense. Let's take a couple moments to just try to have a few deep breaths, you and I. Okay, I'll just breathe in. Do a little meditation here. Breathe in. And breathe out. Breathe in. And then breathe out. One more time. Breathe in. And breathe out. All right.
Alessi, do you have anything?
I can do it, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well, you know how much time Mr. Brennan's...
I'm just asking you.
I will, so, Your Honor.
Okay.
Oh, you're mad at Alessi because he might actually try to participate in this, and you're worried about whether or not they're going to get to ARCA Part 2 because of this? I don't know. Maybe, Bev, maybe you just have to extend your work day. Maybe you have to work a little bit later tonight, Bev. Put pressure on the defense to speed this up. Fucking bullshit.
May I approach the witness?
Yes.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolfe, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like to be part of the hearing.
Sure, we can mark it.
Yeah, that's exactly. Thank you.
Exhibit 2.
Thank you. I offered it into evidence, Your Honor.
Okay.
May I allow the witness to have that?
Yes.
Thank you. Take it. You're with me, Your Honor. Dr. Wolfe, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCA had in our possession, we produced.
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCA?
Let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering...
The audio is much better on other stations. Well, do they have banner issues and stuff like that? Because I'm happy to change it. Which feed would you like me to try, Paige? Which feed would you like me to try? So the audio, which one would you like? That doesn't have huge banners and huge which one would you like me to do? Just tell me. Just tell me the answer. Boston 25? Okay, fine. You got it.
And I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe
Dear hearing, had there been any substantive conversation
from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCA?
Certainly, as is alluded to in the email, was I prescribed to him our typical operating procedure for when a case comes in. But again, I remember part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics, and when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea, hey, can you come this day, right? And then I would relay that to Dr. Rensley and say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Now let's go to the next tab. With regard to the outlines that you were asked on direct examination by Attorney Brennan. you've described this situation, well, you described how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government, there's rules of the road, so to speak, as what you can do, what you can't do, and then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
Was there any other motivation that you had in sending that outline in that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours in your mind to help the defense more than to help the Commonwealth?
No, it's impartial, and I will note I give numerous presentations, and I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic, and I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond, and I think when I sent the direct outline, it was Sunday evening before I hopped on a plane, and I think by the time I got into Boston, it was like 1 a.m., so I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
Do you recall any member of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony while during your trial testimony?
I don't think that was asked.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? Do you remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
At the end of the trial, did you have any understanding whatsoever that ARCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the records certainly reflect that I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel, expenses, disbursements that you had or incurred up to and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Is this the stupidest hearing you've ever been a part of?
December of 2024. Were there any conversations from the end of the trial until December of 2024 other than logistics? Well, was there any conversations of any kind? And please summarize briefly what they were. Or texts.
The only communication I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was, it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense?
Just ask when he stopped beating his wife. I mean that's the level of stupid we're at this point. Just someone cut to the chase and ask him when he stopped beating his wife, because that's how stupid this thing is at this point. I can't be bothered. This is so dumb. Alessi is like, why are we here? What the hell is going on? This whole thing is dumb. What the fuck?
With regard to the potential, well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Now let's go to this year. Did the defense approach ARCA to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding ARCA and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? You know, why are they talking about me? Why am I getting all these hate emails? So it was, I think, a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCA or myself.
So just so I'm clear on that, it was, you believe, regarding comments about ARCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, you know, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Ms. Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
And my understanding is it's the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, etc., do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, etc., did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Rentschler and myself are particularly interested in are extremely vague in that report and PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCA's business to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time would it take ARCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward, he immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative term 800 gigabytes? Is that a little data, a medium amount of data, or a lot of data?
voluminous.
That's a fair amount of data. It's a lot of data. Even that video, that's a fair amount of video.
That, and again, I feel like
800 gigs is a fair amount of data.
Always more time, right? So in a case like this, I mean, ideally we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly
I remember when I got my first 1 gigabyte hard drive.
What did you do?
I remember when I got 1 gigabyte hard drive, and I thought that was more data than anyone would ever need, ever.
As quickly as you could once you got the level of information you had from Aperture.
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Rentschler, to review that material, and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at ARCA to work on this matter?
Absolutely. Work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So,
So it affected his personal life, I understand.
Okay, I'll move on, Your Honor. With regard
Oh, heaven forbid he talk about his wife and his 10-year anniversary. Take away that little moment of humanity from him. You took away that moment of humanity from the man. How dare you? How dare you take away his moment of humanity? That's just low. That's low.
to the work. You performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
correct.
You said you would like to have had more time, correct?
Correct, but I understood Your Honor's order, and I wanted to beat that deadline, so I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline, and we completed our testing.
And with regard to the testing now that you worked on, that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth Aperture and the new information
she said it. Sorry.
Aperture Science.
There we go.
Aperture that came in iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides in hand?
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Do you have in mind, or does ARCA have in mind, any further testing that you need to do, or have you completed what ARCA needs to do with regard to fairly and properly responding to the new work of Aperture?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video, so it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully to my next question, which is there's nothing that you have that you've done that hasn't already been produced pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long on an expedited basis. Well, let me ask you, in the ordinary course, how long would it take you to do this last part of your work, in the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
Not good enough for this judge for some reason. I'm quite sure. Oh, Brendan's going to talk some more. Brendan's about to get up and talk some more. All right. I need a minute. I need a minute before we can listen to Brendan. Okay. I need to just literally step on my balcony and breathe and resist the call of the void to jump. Shut up. Busy. Never mind. It's fine. It's fine. Fucking fine. It's fine.
Doctor, you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I
April
think
1st.
a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically
sure we
about
are.
how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
Just the report?
Yes.
I didn't know that.
And
No.
the file in its entirety was turned over by February 5th? Did you know that?
Objection, Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCA, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now, so wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True.
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal with this information. You said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCA's did, in June of 2024, didn't it?
I believe it was sometime last year,
Do
yes.
you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by ARCA or the defense to try to facilitate an agreement that the defense could use ARCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use ARCA, or specifically you and Dr. Renchelier, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Renchelier so you could review the materials?
Objection, Your Honor.
Do you know? Do you happen to know that?
I don't know, no.
Next question.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025, isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Is anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
The one that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yeah.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No, it was just verbal
And
communication.
they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was, as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor. Okay. This is your outline with your comments. You recognize this?
Yes.
I'd like to just as an exhibit, please. Thank you.
No, I need a minute. I need a minute. Everyone take a moment. Stretch, please. Everyone take a stretch break. I need 30 seconds. Excuse me. Jack Russell, you think? All right, let's do this thing.
So as an expert, when you receive information, you need time to look at the raw data, don't you?
Potentially, yes.
You need time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read, if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month, to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new, and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert if they wanted to do testing based on new testing that you provided over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report, you provided the report. How many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected. It's classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstration, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one, so
Okay.
no, I want you to focus on.
Okay, no, that was not produced, no.
You never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided in response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
I think you might be confused. Again, our role for this round.
I don't think I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw data, no notes, correct?
Correct. But for this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We have
asking you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking you. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel with that.
This is the fucking stupidest part of my day. This is a fucking stupid thing. Fuck, dude. Fucking dumb fuck. Yeah, we need an apartment friendly dog. We need an apartment friendly, lowish barking. It would be nice if also it was kind of lowish shedding for my allergies too. That didn't shed as much. Would be nice.
You're all set, and let's bring Dr. Rentschler in here, please.
Thank you, Your Honor.
Okay.
Oh God, thank God that's over.
Follow me, sir.
Bev actually just called an end to it. She should have called an end to it a long time ago. Let's get doctor number 2 in here for whatever this is, man. Yeah.
Thank you.
I do.
Please state your name for the record and spell it.
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
In a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
Okay. How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I...
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
Well, I don't believe that ARC has any specific policy for that, no, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before a trial?
With the DOJ, you mean? Yeah. Well, certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order, that there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came to court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness, so before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you wanted to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an opinion.
You make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done?
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you ordered me to do so, I mean, I could certainly try and expedite it, yeah.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right. I'm going to see counsel at sidebar for 1 minute.
All right, that was a lot shorter. I guess Bev heard enough, which I don't blame her, to be honest. Like, we weren't getting anything more out of that witness, so I don't think there's anything here. I think this entire thing is bullshit, and I think this entire hearing was a waste of time, and it's dumb and stupid. And I also think that May 7th is plenty fast enough, because ARCA's not going to be called for, a month.
All right.
And then
That's it.
like,
Thank you.
yeah, I mean, this is dumb. This is complete dumb.
Goodbye.
Is that it? We're not having any decisions? That's the end of the hearing? Oh, okay. Okay, I guess it's the end of the hearing. So as I was saying, yeah, I just don't see that. I don't see that. First of all, I just don't see anything nefarious in any of that. Despite Brennan's desperate attempts to make something nefarious, there's just nothing nefarious there. It's perfectly ordinary, routine, normal stuff. There's nothing that is odd or different. If anything, it's less than you would expect. That apparently they had no conversations relating to their testimony, the substance of their testimony prior to the putting on the stand, which is pretty unusual, right? I'm going to call an expert witness to the stand and have absolutely no idea what they're going to say. That sounds like a dangerous thing. Like, what isn't one of the fundamental rules of being a lawyer? Like, don't ask a question you don't know the answer to. Isn't that usually a pretty standard question, pretty standard guidance? And it's like, not only am I going to ask a question I don't know the answer to, I'm going to ask every question and I don't know the answer to any of them. That sounds like super fun for me as a lawyer. That sounds super fun. Let me put this expert witness on the stand that isn't my expert witness. I haven't prepped. I have no idea what they're going to say. I'm just going to ask questions and hope it all turns out well for me. That sounds like a malpractice nightmare, to be honest to me. That's the first thought that goes into my head. You want me to put an expert witness that I didn't hire, I haven't prepped, I have no idea what they're going to say, and you want me to put this expert witness on the stand in my case and just eat anything they tell me and just eat any answer they give me because I have no ability to control it. That sounds like a ticket to malpractice land. Did they call their malpractice insurer in advance and be like, let me run this plan by you? Because I don't know about this plan, man. I don't know about this plan. That sounds like the worst idea I've ever heard of in my life. But apparently that's what they decided to do. They decided to put these people on with no prep, no planning, no idea what they're going to say and be like, so what do you think? You want to tell me some stuff? Hope it works out for me. And I guess it did. So, I get, but other than that, there's nothing nefarious about this. There's nothing unusual, nefarious. And the only other aspect of it that's pretty weird is that there's no explicit agreement about who's going to pay. It's like, yeah, I'm going to come and testify for you. And we have no signed agreement. We have no retention agreement. It's like, that's pretty weird, but that's just the way we're rolling. Apparently we're rolling in a strange land with strange rules and strange stupid. But apparently it worked out. And then Brennan over here wants to make, a huge deal out of all this stuff for some reason. And there's just nothing behind any of it. There's nothing there. There's absolutely nothing there. He's just trying to make everything sound so nefarious. It's like, what do you mean you can't remember exactly what you said on a call? This is what I was trying to tell you guys earlier with respect to the witnesses, by the way, that you were giving a hard time with. I was trying to tell you this, and some of you guys weren't being very receptive, but I was trying to tell you the same thing with respect to some of these other witnesses, like the EMT and the firefighter. It's like they were under oath. I'm like, yeah, but it was like 2 years ago. It was a year ago. And they told their beliefs. Yeah, but it's like, do you remember every conversation you ever had? And like, they should. It's a murder trial. They should absolutely remember everything. Yeah. This is why I was trying to tell you, people just aren't like that, including incredibly educated people, including people with, all the science degrees ever. It's just like they don't necessarily remember exactly what happened in exactly every conversation, and it's everything, and you just can make it sound nefarious. Aren't you lying by not telling us things? Like, well, there's just like, don't know for sure about certain things. So, there is a human factor in this and all the rest of it. And also, basically, Brennan did exactly what AJ did, but Brennan didn't do it in front of a jury. So Brennan was basically trying to eke like every last scrap out of this. But where AJ AJ's mistake was he did it in front of a jury. And so he has to have the jury like them. Brennan wasn't trying to get anyone to like him because there was no jury present. So while jury was being as much a dick, even if not more of a dick than AJ, Brennan had the advantage of not having to do it in front of the jury, so he didn't have to worry about the potential of losing face. So there was that part of the calculation. Of course, when they actually testify, he will have to recalculate accordingly. But for today's purposes, it was, what it was. So yeah. Yeah. And I don't remember conversations I had yesterday. It's like I've made mistakes about what I've said on a stream, or, there's definitely been times when people have called me out and be like, didn't you say this or didn't you say that? Or it's like, no, I don't think I said that. Or I think you're I make mistakes about what I've said in the past, or my memory isn't perfect. It's like, so yeah, it's like, so yeah. Anyways, it was one of the stupider hearings I've ever heard of in my life. It was incredibly, incredibly dumb. It was incredibly, incredibly dumb. What watch do I have? I'm wearing the Citizen ProMaster Tough Ray mirrors right now, and I like it a lot. Yeah. In terms of what the judge is going to do here, your guess is as good as mine. It appears the judge is considering extending her grace to allow them to have until the 7th to finish their report. It appears the judge is just there to like be a dick and probably isn't actually going to do anything. So yeah, probably it's just like get us to us by the 7th and call it a day. That's probably where this is going, but of course we don't know that for sure. Yeah. She does love herself some Brennan. Yeah, everything that guy does is glory. His questions were so incredibly dickish. His questions were so dickish and so aggressive. And so, it's like, really? Are these really the questions you brought me in here for? Yeah, let's do A Few Good Men. Are these really the questions you brought me in here? Foot lockers and phone calls? Please tell me you have something more. This woman's on trial for her life. Please tell me you have something more. Yeah, it's like that's what we need to channel, some Few Good Men bullshit in there, right? Yeah. So all that stuff, man. Yeah, probably strongly admonish the defense, and not much else will happen. Let's see if there were any super chats I missed along the way. David Case for 499 said, out of the trials, the ARCA guys are some of the most professional we've seen. Yep. Mark Bassett, the world's largest rage room is in Houston called Break Life Houston. I think Uncivil might need to go to Break Life Houston. It's a rage room is a room where you go and you can pay to break things. They'll give you like a baseball bat and you can like break plates and smash stuff. Feels good right about now. And Osborowski gave me $2 to say Inquisition. Wild Doe became an uncivilian. Snarky Puppy gave $2 to say routine Brennan. Do you understand the concept? Jules said, wouldn't some of this be badgering? Yeah. Sledge and Wedge gave me $3.14 to buy a professional consummate. Josh H. Brennan's only doing this so Kay Peters can run with it today later online. Maybe. Josh H. says, what is Brennan even trying to get at? He's not trying to get at anything. He's just trying to make these things happen because he's a dick. And Asperalzi said, bringing back to Brenning up, he's giving him a nightmare. Terry became an uncivilian. Stark Yo Lady became an uncivilian. Do they let you primal scream? I think you're allowed to primal scream. Yeah, I'm pretty sure you're allowed to primal scream. They give you some safety goggles and a baseball bat, and you can destroy some plates, and they might have a car that you can beat the shit out of, and other things like that. It's fun and exciting. Yeah, you need a rage room. You and me both. We could read more. We could read more insulting comments against Uncivil, because I'm still there from earlier. I'm still there from earlier, and my mind is fixated on mean things said about Uncivil, because it was like universally negative comments. So we could read that some more. Is this another hat? No, it's the same hat. It's always had that band. It's the same hat it's always been. Yeah. Yeah. Why is the judge letting him badger? This was the judge's entire idea in the first place. The judge was probably getting her jollies off watching it, to be honest. She hasn't felt anything for a while, and this is how she feels things. It's straw hat time? Yeah. Do people tell you bad chats have big channels? I don't think that's necessarily it. I mean, whether you have a big channel or not doesn't mean that you're necessarily right. Your rightness isn't necessarily in your channel size. But, when like everyone is telling you, or like when everyone who is responding to that is basically negative, it's like, well, maybe there's a point there. Maybe they're making a point. I don't know. Don't ring negative comments about yourself. That's probably for the best. I'm hungry too. I'm hungry and I need food. I'm trying to reduce my channel success. Yeah. Denny's. I don't want to go to Denny's. I have food. I just need to cook some. I seem depressed today. Well, I was in a good mood, and then someone mentioned Alyssa Clips, and I decided to go read comments on Alyssa Clips, and it kind of bummed me out because it was really negative. I had this huge reaction yesterday to this brief I was reading because it was bullshit. And, I was exasperated because it was bullshit. And, but on Alyssa Clips, she posted a clip of it, and the comments basically are universally negative towards me. Accusing me of being autistic, accusing me of being, socially having no social, sense, no sense of how to get along with others. No, just being obtuse, being unlikable, being autistic, being undiagnosed with some sort of anxiety condition or something, bipolar, all the rest of it. What happened? I'm telling you what happened. Why are you asking me what happened? I'm telling you. Yeah. Yeah. But I reacted as strong as I did because the guy made a completely invalid argument. And so yeah, I did this analysis of this brief that I wrote, the Supreme Court brief I did. So I decided it was a good idea for some reason to ask ChatGPT to do a comparison between the brief that I wrote and the guy that the client hired after me. I asked them to do a side-by-side comparison. And ChatGPT preferred the other person's brief, but in no small part because ChatGPT mentioned it a couple times, ChatGPT favored it because the other guy made a circuit split argument. And ChatGPT notes correctly that a circuit split would be a really good reason for the Supreme Court to take the case. That's their most typical reason for granting cert. That's the most likely thing for them to grant cert for by far. And so like, well, ChatGPT was like, well, there were other reasons it liked his style beyond that, but it was a huge part of its analysis. And so I was like, okay, well, did I miss something? Did I miss a circuit split? Because I thought I had read everything. Because I worked really hard on that brief. I worked very, very hard. I think I read everything. I think I read everything that has ever mentioned you, Sarah. I read all of it. I read so much stuff. I read every single case that even talked about it. And then I read I think I read every law review that talked about it. And then I read so much shit. So I was like, okay, did I somehow miss a circuit split? Did I somehow miss this thing? And so I went to look into his brief, the guy that they hired after me, and he says there's a split. And I'm like, well, he cites this case Torres, which is a U.S. Supreme Court case. He cites this case Torres for the proposition that there's a split in the Fifth Circuit. I'm like, well, it's a U.S. Supreme Court case. Let's go look. So I go read Torres. Thank you for the $50 super chat, Deb. That's very, very nice of you. So I go read Torres. Torres isn't a Fifth Circuit case. Torres isn't a federal case. Torres was a state case. Torres was appealed from the intermediate appellate level of Texas, which, is unusual unto itself, but it was, right? So Torres, the guy, Torres went to the military. He claimed that he suffered a disability, namely that he inhaled toxic smokes and stuff, and that made him hurt his lungs and stuff. And so it made it difficult for him to be a state trooper, which was his job. So Torres says, I was a state trooper. I did my military thing. I was exposed to some burn pits. I breathed in some toxins. I find it hard to be a trooper anymore. Can you help me? He loses at trial court. That's in Texas state. Now he files a federal cause, but he files it in state court. You can do that. You can file a federal cause in state court. I'm not sure why he didn't file federal. I mean, presumably he had his reasons, but he didn't file federal. He filed state with a federal cause of action. For whatever reason he did. So he's suing in state court on a federal cause of action. And the trial court says no on the basis of sovereign immunity. The intermediate appellate level of Texas says no, sovereign immunity. The Supreme Court of Texas does not take the case. Supreme Court of Texas does not review it. So only one place left to go. Off to the U.S. Supreme Court. The U.S. Supreme Court decides to pick it up, which is pretty unusual, right? I mean, they picked it up from an intermediate level, state level appellate court. They didn't even go to the state high court. They picked it up. For whatever reason, they want to pick it up. It dealt with a sovereign immunity issue. I don't know, maybe that's why, but it's still kind of notable. It's pretty notable they picked it up. You probably would not have predicted that they pick it up, but they did. You would, if you had to predict it, you would say, no, they're not going to pick it up, but they did. So they can surprise you. So the Supreme Court picks it up. And they're like, okay, this guy's suing under 4313, which is the same thing I was trying to sue under, or my client was trying to sue under. But they don't actually discuss the merits of 4313 at any point in the analysis, because that wasn't the issue. The issue wasn't the merits of 4313. The issue was, can I sue Texas at all? Sovereign immunity. Texas says you can't sue me. That was their defense. You can't sue me. It wasn't, you're not really disabled. It wasn't, you weren't disabled as a result of combat. It wasn't, we didn't discriminate against you. It was none of those things. It was simply, you can't sue us. And so the U.S. Supreme Court decision is entirely about, can I sue them? Right? It has nothing to do with the merits of the cause of action. The Supreme Court doesn't comment about the merits of the action. They don't say like it's a good cause of action or it's a bad cause of action. They have no comments about this because it wasn't the question they're asked. The only question they're asked was, can I sue? And the U.S. Supreme Court says, yes, you can sue. Now, whether or not he has a good cause of action is yet to be decided, right? Back to square one. And now, you can, fight about it on a different basis if you want. So this guy cites this case, and I didn't cite the case at all. At no point in my brief did I even cite Torres. I never cited it. And I'm like, well, no wonder I didn't cite it. It doesn't have anything to do with my issue. My issue doesn't have anything to do with this. No wonder I didn't cite it. It has nothing to do with it. It's at best a throwaway site. It's at best a see also site, because it doesn't really have anything to do with what I'm talking about. It's just 4313 appears in the case, but it's not really what they're talking about. So it does. So like, yeah, whatever. So like, anyways, but he says this case is the basis for saying there's a Fifth Circuit split. And I'm like, no, it's not. It's not a Fifth Circuit case. It's not a federal case. It was a state case. So it's not the basis for a Fifth Circuit split. And so he cites this as the basis for a split. And I'm like, no, it's not a split. And then it's worse than that somehow, because at no point did he cite any case out of the Fifth Circuit, including at the district level. There's 3 states in the Fifth Circuit. There's what, 6 or so district courts in the Fifth Circuit, something like that. It's like he didn't cite any. There's no citations. And so I lost my shit. And screamed into the void, that there is no split. I am a lawyer. I can read. I am a lawyer. I know what I'm doing. There is no split. There is no Fifth Circuit split. At no point does he cite it. And I'm just screaming into the void about this because it's like, it's absolute bullshit. It's like, no wonder I didn't cite this. It has nothing to do with anything. He's basically, his entire his entire first question presented is essentially based on this split. That is the basis of his first question presented. He's like, this is the reason you should grant the first question presented is because of the circuit split. I'm like, there is no circuit split. It doesn't exist. So his entire legal argument just falls apart completely. There's nothing there. It's just an empty legal argument. It's written in a more traditional white shoe style. It's written in a more reserved style than what I wrote, but it's a completely empty argument. There's nothing there. So I rant and rave at the stupid because ChatGPT scored this guy more positively than me in no small part due to this issue. And then I also asked ChatGPT to rescore accordingly because I'm like, there's nothing here, which I didn't actually put that on screen, but as long as we're talking about it, I asked ChatGPT to rescore because I'm like, this is empty. There's nothing here. So I'll share with you because, it's like, you're just wrong. I mean, like the basis of your opinion. ChatGPT is like, well, this guy's talking about a circuit split, but it's empty. So well, ChatGPT wouldn't know that. ChatGPT doesn't know it's empty. It's not a lawyer. It doesn't know it's empty. So it's scoring it based on the proposition that, there's something there and there's nothing really there. So, so I ask it to rescore. I was like, I need you to rescore your decision. So I said, the circuit split that the Meyer petition alludes to does not exist. The Meyer petition cites no Fifth Circuit case at all, nor does it cite any cases at the district level for trial courts within the Fifth Circuit. The Torres case it cites was not from the Fifth Circuit, nor was the decision material to any of the issues presented in the petition, because it's not. So I'm like, take this new information and rescore. And so, so then based on my providing that information, it says what the Meyer petition really says. In 2 places, it implies the district courts in Fifth Circuit would let PTS evidence in. It doesn't so much imply to say it outright, where the Seventh Circuit excluded it. It cites no Fifth Circuit Court of Appeals precedent, nor district authority to back it up. So it's like, well, how do you know a district court would allow it? How do you know that? You don't have any examples of it ever happening. It might be true. It might be true. A Fifth Circuit court might very well render that decision. It's certainly possible that they would, but you have no particular basis for believing it. Other than the fact that, there's like 94 districts in the country, and let's give, another one a shot. And, maybe we'll get a different answer. But like, you have no particular basis for believing it. So it's like, you just believe it because wishes. And then like the only Texas case it cites is this Torres case. Torres is a Supreme Court case involving sovereign immunity. It doesn't arise from the Fifth Circuit and doesn't address the 4313 evidentiary issue, which it absolutely does not. Right? Thus, the petition asserts a conflict without authority. In Supreme Court practice, this is worse than admitting a split entirely. Rule 10 asks for conflicting decisions, not predictions or impressions. Yeah, he's arguing authority that doesn't exist. So I'm like, okay, then it gives me a rating of this, comparatively. And so then it says, likelihood of cert grant adjusted. Absent a real circuit split, both petitions must rely on the important federal question prong. It's like, yeah, we don't have the circuit split. So all we have left is, this is a question of major importance, or this impacts a lot of people, or ground number 4, we just want to beat up on the district court because we don't like them. So like, we have to find something else. It's like, yeah, we can't make the circuit split work. Meyer now loses his biggest claim to advantage. Worse, the court and clerks will spot that the split is unsupported because it cites no authority. He doesn't cite any authority. He just says it's true. At like 3 or 4 different places, he says the Fifth Circuit would do this, and he doesn't have one citation, not one. And that's why I'm screaming, not one citation, right? Yeah, Mueller's petition never promised a split, so it suffers from no credibility penalty. Bottom line, with no demonstrable conflict, the petitions are roughly even on cert-worthiness, but Mueller's single issue, single question focus is now cleaner. Meyer's filing still is polished, but the overstated split plus the extra 88 question both weigh it down. You tell him. Given the corrected landscape, advantage swings to Mueller. It does not overclaim a split, so it avoids the credibility hit. Its single question presented keeps the court's attention exactly where it needs to be, whether excluding PTSD evidence under 4313 violates USERRA. The veteran impact narrative, while emotive, highlights the national importance, which is the factor now most likely to matter. Yeah, that's the reason I did it. Like, I can't make this work on pure law. I can't make this work on a pure legal analysis. I mean, I'd prefer to do that. That'd be nice, but I can't do what isn't there. I'm stuck with what I have to work with. I can't just create something out of nothing, So it's like, well, I got to make a way to try to make this seem more important than it might naturally be. I've got to make this elevate somehow. So like, well, how am I going to do that? How am I going to elevate it? And so I decided to talk about veterans and PTSD and wave the flag a little for a while, perhaps too much, but that was why I was doing it. Meyer's petition remains professionally drafted, but unsupported conflict is a substantial blemish. At best, the court will ignore the claim split. At worst, the overstatement could make the petition look clareless. Accordingly, if the client must choose one to file, the Mueller draft is now the stronger candidate. Yeah, you tell him, ChatGPT. So I expressed my strong opinions relating to this bullshit in what has been described as spurging by my detractors on Alyssa Clips. And I was very, very frustrated because, I thought maybe somehow I missed something, It's like, geez, I thought I did my homework. I thought I did something, but maybe this guy knows what he's talking about. Maybe somehow I missed an issue, or somehow, some way, despite all my prep, despite all my planning, somehow, some way, I maybe there was a way for me to make this into more, maybe I could have done something, and I read it and I'm like, oh, it's all empty. It's all lies. And so I expressed my frustration at the lies with some notable energy. And apparently that makes me an ADHD, socially inept, undiagnosed manic depressive, spurging autistic loser because I was kind of emotionally involved in it because, I cared about the case. I cared about the client, cared about it. And, this guy is writing lies or, it's like, it's just empty. And, you could still critique me. There's lots of ways to critique me. You could argue that I should have dropped all the PTSD stuff. You could argue that and just made it more pure law focused. The problem with doing that is it doesn't get me anywhere. It doesn't really work, right? So if I had dropped like all that stuff, because I wrote about it for like quite a while, if I had dropped all those pages just dealing with veterans and PTSD and citing medical studies and citing, how it impacts 29% of veterans and 3 times more. And it's like, if I had dropped all that stuff, it would have been a pure legal focus. But the problem is it just doesn't get me anywhere because I know I don't have enough. I know I don't have enough because I don't have a circuit split. It's not, a constitutional crisis. It doesn't like involve some like major issue dealing with separation of powers. It's not really a case unto itself that really impacts a lot of people. So I've got to make it seem like it impacts more people than it does, or at least got to try to convince them it impacts more people than it does. So I'm going to start talking about the millions and millions of veterans who deal with PTSD and try to show that this is a real issue that impacts a lot of people, and also show them, those things because, I wrote it for those reasons. So I could drop all that stuff, but the pure legal analysis doesn't work on its own. There's not enough there. So, it's not going to work. It's not going to work by its own. So I'm like, well, I guess I could have like toned it down. Maybe I could have cut it down in volume, but and it is a little emotive in its language, but I'm trying to make them care. I'm trying to make someone care about this, and the only other thing you could say about it is, the only other thing you could really say about the petition is at times it uses overly aggressive word choices to critique the lower courts and critique the decisions below. It uses overly aggressive language, and it should have been more moderated language. But that's an easy fix. You're just talking about changing a word choice here and there, in your titles, just changing some of the language, to slightly more moderated verbiage. And you wouldn't lose very much by doing so, which, fair critique. You wouldn't lose very much. And you possibly even gain something by seeming a little less passionate about the thing and seeming a little bit more neutral, because the Supreme Court kind of likes that. They do like a little bit more neutral. They like this as more of a learned, they like their lawyer. They like advocates who come. There are exceptions to the rule, but they do like people who tend to approach things in a more objective fashion comparatively to how you might present things in other courts. So, that's a fair critique, but, what can you say? And that's me attempting to be as honest about my own work as I can, which is inherently a difficult exercise because I wrote it, and obviously it's hard to be objective about yourself. It's just literally difficult. It's hard to see what other people see because you're putting it through. Even when you're trying to step outside yourself, you can only really get so far by trying to step outside yourself, because you're still constrained by your own thinking and your own patterns of thinking. It's very, very hard for a person to see in themselves what other people see. That's difficult. And I try to be self-reflective as I can. I try to be as self-reflective as I can about it, but I'm limited by my own perception. And there's really sort of no way to get around that sort of in the end. So another lawyer might very reasonably disagree with the choices I made, and to be fair to myself, I suppose at some points, there's just no right answers. At some points it's just trade-offs. There's no answers. There's just trade-offs. And, some of those trade-offs may be, assessed by a different lawyer, differently than me, but it's like you're still like making trade-offs. It's like the thing about dropping the ADA cause of action. It's like dropping that ADA cause of action because I want them to focus on USERRA. I don't want them to get lost in the ADA. I want them to focus on, if I don't give it to them, they can't focus on it. The strength is the weakness, right? The strength is the weakness. By not giving them ADA, they can't focus on ADA. But by not giving them ADA, they can't focus on ADA, right? The strength is the weakness. And so like you have to make a decision about like which of those do you like best? And I made a decision. I think it was the right decision for the client, in my humble opinion. Different lawyer might disagree, but I'm gonna lose a cause of action, not for at least the reasons that like basically anything I can do in the ADA, anything that the ADA gives me, I can get in USERRA, but not the other way around. USERRA gets me at least as much as the ADA, but ADA doesn't get me as much as USERRA does. So I can lose ADA, keep them focused on USERRA, and anything I need from the ADA, I can push into USERRA, and it'll be fine. But I can't do it the other way around. I can't steal from USERRA and put it into ADA, because USERRA by its own terms is greater than the ADA. So I can take from the lesser and put it in the greater, but I can't take from the greater and put it into the lesser. So it's like, well, I'm dropping this to make them focused on it because that's what I want them to do, because I think it's the best cause for my client. And if she has the ability to present the information to the jury, she wins. Because that's the question I'm asking them to consider, whether she has the right to present the information. We already know she wins. She already won before a jury. She already won before a jury previously. So like, I'm like, if she can make the argument, she wins. So not only do I win the Supreme Court argument, she wins the trial and she gets her $7 million. That's a good day for her. If I can get the Supreme Court to take the case, which is the challenge, right? I was reasonably confident that if they took it, I'd win on the merits. It's like, if I can actually get the Supreme Court to somehow pick this case up, I was pretty confident I could get them to win on the, I was pretty confident I could win on the merits. I was like, I think I've got 6-7 votes, easy, and I might be able to do better than that. Everyone loves veterans, Everyone loves veterans. So I was like, if I can get them to pick it up, I can win. But getting them to pick it up is the challenge. And so, but everything I did was in service of that goal, as you would expect. But apparently, my reaction to the person that my client went with, and being like, apparently my reaction of your brief is full of lies. Apparently that reaction was unprofessional. Apparently that was indicative of undiagnosed borderline personality, anxiety issues, autism spectrum, lack of social awareness, and other things. Yeah. So that's what happened. Yeah. Yeah. So yeah, also I wasn't in frequent court. Also, yeah, that also too. Right. That would obviously, I know how to behave myself in court. Yeah. And I feel, if it had come down to it, I feel like I could have won on the merits. I really do. I felt like the statute was pretty clear on its own terms. The statute's text is real. I sort of have everything you need on the merits, right? The text itself is clear on its own merits. So I've got like Gorsuch's vote, also I've got all the originalism markers. Not only is the text clear, but all the history is clear. The intent of Congress is clear, right? So I've got pure text, I've got intent, I've got history, I've got precedent, and I've got policy. I basically have every possible legal argument in my favor. Those are every possible argument, and they're all winners for me. Those are the arguments. Everything boils down to one of those arguments: intent, text, history, precedent, policy. Those are your 5 arguments at the Supreme Court. Those are your 5 arguments. Everything you say is one of those 5 arguments: text, intent, history, precedent, policy. Right? And I've got them all. The text is clear on its own terms. It's clear on its own terms. It just says it in black and white. The history, how did it come about? I cited this history. It's like, oh, I've got this Vietnam era law. I've got like 3 different Vietnam era laws. I've got a different law. I've got literally one of the first laws Congress ever passed. One stat 273. On the 273rd page, of all the laws Congress ever passed ever, right? On the 273rd page of all the laws Congress ever passed ever, they have a law that deals with exactly my subject matter. It's like, well, it doesn't get much better than that. I've got it going back all the way to the founding of the country. Like literally one of the first things Congress ever did was basically my stuff. It's like, I don't know how much more deep history you got, right? I've got my text, I've got my history, I've got precedent, I got cases from the Supreme Court interpreting its predecessors that, basically say liberally construed and all the rest of it. I got precedent. I've got, the intent of Congress seems pretty fucking clear on its own terms. Plus, I cited the congressional record at several points, Plus, also, I've got, because Chevron was still good law at the time, I've also got things from the Federal Register. I've also got things from the Federal Register, from the Department of Labor and the Department of Veterans Affairs that say I'm right. Right? In terms of, I got that going for me. Right? And I got policy. Protecting the troops is a good thing to do. So I've got literally every single argument. I've got all of them. So I'm like, yeah, I think, I'm going to do pretty good at the Supreme Court. Figure, I figure I've got pretty much of, say, 5 votes. I figure, if I can get them to pick up this issue, if I can get them to care, I will win. But getting them to pick it up is the challenging part. And, as I said before, the Supreme Court had seemingly been on a bit of a veterans kick as of late. They had picked up not like an absurdly high number of cases, but a disproportionate number of veteran cases compared to their normal caseload. So they had been on a slight uptick in veterans cases, which also was possible. So it's like, well, I'm definitely, and that's one of the reasons I did what I did. I picked the veterans. One of the reasons I focused so heavily on USERRA is because I want them to pick it up because it's a veterans case. It's one of the reasons I talked about veterans, because it's a veterans case. I'm trying to do everything you can do to possibly get the Supreme Court to take this up. I'm doing everything that there is within my power to make this work. It's all in service of the client. And, everything in my brief was true. It was all true. It's all as good as I could possibly make it be. I did my best. So it's like, that's sort of where the game ends. Yeah. So, yeah. That's where it is. So, yeah. But, yeah. I thought it was good. Other lawyers might disagree, but yeah. So the guy who filed it got rejected by the Supreme Court, unsurprisingly. So the guy that they hired got rejected with no comment, which, was by far and away the most likely thing to happen. So, but he got rejected with no comment. So that was the end of the case. Yeah. But people were very critical of my reaction to this bullshit. So, yeah. Well, anyways, we're going to be on tomorrow. So let me schedule a stream for tomorrow so I can like redirect you there so you can like it. So give me a second to create a thumbnail for tomorrow and create a stream for tomorrow. This is going to take a second. Please hold on. Talk amongst yourselves. I was upset because I care. I was also upset because the other guy's brief was bad. It was lies. It's like there's no split. I can't believe he wrote it. I can't believe he wrote it. I mean, I thought maybe he was trying to take some district level case. I thought initially what he was trying to do is take some district level case in the Fifth Circuit and try to argue that that's the split, which it still isn't. But I thought that's what he was trying to do, and it's like it's even worse than that. There's actually nothing here at all. So it was really, really frustrating. And apparently me screaming, I'm a lawyer, I know what I'm doing, I'm a lawyer, I know what I'm doing. Apparently me screaming that was bad form or something. I don't know. So, yeah. I'm not sure Brown is doing us any favors. That's, I don't know about the black on white. Let's see if I can find something else. I'm looking for a background I can use. This one might work. Let's give this a shot. Yeah, that sort of works. All right, we'll go with this background. Are we done with ARCA? Yes, we're done with ARCA and the voir dire. No answers, of course. Not that you expected one, did you? Can I like redo this stream? Schedule this. Okay. So this will be the 26th or the 6th day on the 29th. Change the thumbnail. Okay. Yep, that'll work. I'll just keep the description from yesterday. I can't be bothered to rewrite it right now. Schedule it for 7:15 in the morning. 7:45 in the morning, rather. My time, of course. All right, and we're going to stream that to those 5 platforms on the 29th at 7:45. Schedule, create event. Schedule faster, please. All right, guys, make sure to like the stream for tomorrow, please. Go ahead and like it when you get redirected over there, and I really appreciate it. I will see you guys tomorrow. I've been on Civil Law. Till later, my friends. I hope all is well. Cheers for now, my friends, and goodbye.